Meeting is now being recorded.
Okay, so again, we've started the recording. This is Susan O'Rourke from NYMER, and at this point, I'd like to introduce Kevin Crawford, NYMER's Executive Director. And also, if you have your webcam on, if you could turn your webcam off. I think someone might have their webcam going. All right, Kevin?
Well, thanks, Susan. Let me add my welcome, and thank you all for joining us for this educational webinar, which we hope will cover all the key elements in the new law regarding sexual harassment employment policies. In order to best accomplish this task, we've retained one of our expert panel counsel to take you through these changes. So let me in turn welcome and turn this over to Sue McLaren, who is a partner with the law firm of Webster Zani and who NYMER uses frequently on employment-related claims issues. So Susan, it's all yours.
Thank you, and good afternoon, everyone. I'm so glad to see so many joining us today. I know these new sexual harassment regulations and legislation has created a lot of anxiety and a lot of confusion, if you will, about exactly what they entail. So I'm hoping by this overview seminar to dispel any confusion and to perhaps eliminate the anxiety you have. And so I'm going to jump right in. I hope you all had a cup of coffee so that you can really stay with me this afternoon. Here we go. In the wake of the Me Too movement, New York State made clear that it's focused on curbing sexual harassment in the workplace. So as part of the 2018-2019 budget enacted on April 12th of this year, the state passed legislation clearly aimed at doing just that, curbing sexual harassment. And I want to talk about the key measures passed. Some of them will be more applicable to you, some of them won't, but I think it's important that you have a clear overview understanding of exactly what this legislation entails. And so we'll start with the prohibition of mandatory pre-dispute arbitration clauses. The budget added a new legal provision that states that employers with 4 or more employees are prohibited from incorporating mandatory pre-dispute arbitration clauses in written employment contracts that essentially require employees to submit their claims of sexual harassment to arbitration rather than allowing them to adjudicate them in the administrative process, agency process, or in the court systems. This prohibition applies to contracts entered into after July 11th, 2018. It does not apply to collective bargaining agreements. What I would say is I am guessing all of you are sitting there saying that doesn't apply to me and my municipal entity, because I can tell you in my more than 25 years of representing municipal entities, I am not aware of a single entity that I have represented that has this kind of arbitration provision. It's usually reserved for private sector clients. Nonetheless, if you are thinking of embarking on that, you should be clear that they will be deemed null and void if, in fact, you look to enter into such an agreement in the future. And moving on, and more applicable to you is the ban of
I'm sorry, Susan,
yes?
This is Susan O'Rourke. It looks like a couple people are having some technical difficulties. I'm not really sure. The screen is up. The PowerPoint is on. Yeah, let's see. It looks like we have extra people signing in, so we might be losing because we're over 200. So we've got extra people that have signed in.
The PowerPoint is now missing from my screen.
You've missed the what? The PowerPoint?
The PowerPoint is no longer showing on my screen. Now it is.
Now it is? Okay. Hopefully
yes.
Other people. So it's not. Okay. All right. So let's continue going then, Susan. Sorry about that.
Okay. If you can go back a couple. There we are. Terrific. Okay. The next key measure of the sexual harassment legislation is the ban of non-disclosure agreements. The budget added 2 new provisions that act to ban non-disclosure clauses in settlements, agreements, or other resolutions of sexual harassment claims unless the condition of confidentiality is the complainant's, the aggrieved employee's, preference. And what the law now says, if the complainant prefers to include a confidentiality clause in a settlement or agreement, the complainant will be provided 21 days after receiving the settlement or agreement to consider whether they want a confidentiality clause in the agreement. They then have 7 days after the 21 days expires to revoke their agreement to maintain confidentiality. What this means, if any of you have ever been involved in the resolution or settlement of a harassment or discrimination claim, we very regularly seek to include a confidentiality provision that says that an employee can't affirmatively go out and share the underlying facts or circumstances surrounding the claim, and that only if they are served with a judicial subpoena or if someone makes a FOIL request for the settlement will it become public. Bottom line, what I am suggesting to all of you and what I have always suggested to my clients is that they involve their counsel in any settlement agreement that they enter into, because it typically involves the exchange of money to the complainant, and you're looking to actually resolve the claim where it's overdone and you move forward. Too often what I have seen in my experience and sometimes with my own clients is because I've provided them, let's say, a settlement agreement regarding another matter in the past, oh, we don't have to talk to our counsel, we'll just cut and paste and put one together. This is a complicated new provision that requires a separate agreement and particular language and particular time frames to ensure that you have confidentiality with regard to your agreement. So I would encourage you all, whenever you are involved in the resolution of a complaint of discrimination, that you involve your counsel to take a pass through your agreement to make sure you really are resolving the claim and it's not going to come back to haunt you in the future. A third key provision is protections for non-employees. The budget created a new provision that actually expands sexual harassment protections to non-employees. So as an employer, you may be liable to contractors, subcontractors, vendors, consultants, or other non-employees that are providing services to you with respect to sexual harassment. And that liability will be borne by you as an employer when the municipal entity, your agents, or supervisors knew or should have known that the non-employee was subjected to sexual harassment in the workplace and the employer failed to take immediate and appropriate corrective action. And this provision is in effect since April 12th, 2018. So basically, it opened up a whole new area of liability for employers. While we were always liable to our employees if a non-employee harassed them, we are now liable if our non-employee working in our workplace is the subject of sexual harassment. So that's really important to know. You can't say, oh, there's nothing I can do about that. And then finally, what I think probably most of you came on the line to hear about was mandatory sexual harassment policy and annual sexual harassment prevention training. And so public employers as well as private employers in New York State, regardless of size, are required to maintain a written sexual harassment policy and to provide annual training employees pursuant to this new provision. And that said, that's what's going to be the focus of the remainder of this seminar once we get through a couple of additional provisions that apply to you as public employers. So if we could have the next slide. Yes, these other provisions that apply only to public employers. One deals with the requirements for contractors' competitive bid statement. Under the New York Finance Law now, it requires a state contractor to certify in its competitive bid statement that it has implemented a written policy addressing sexual harassment prevention in the workplace, and that it provides annual sexual harassment prevention training to all of its employees. Also, when a competitive bid statement is not required, the department or agency or official can require a bid statement to include that information noted above. And this will be effective January 1, 2019. So for our where we have to solicit competitive bids, we may want to revise our bidding requirements to include that requirement. And finally, related only to public employers, under the New York Public Officers Law, a public employee who has been found personally liable for intentional wrongdoing related to a claim of sexual harassment must reimburse any agency or entity that makes a payment on his or her behalf within 90 days of the agency or entity's payment. And so, in other words, the New York State Human Rights Law has provisions for personal liability, typically have to be of a particular level in the organization, a supervisory level, to effectuate that personal liability provision. But for example, if you're of sufficient high level in an organization and you sexually harass someone, you can be subject to personal liability, and you cannot have the agency or the municipality pay any adjudicated finding of wrongdoing that results in a monetary award to the complainant that the individual must pay. So that said, let's move on to the issue of the sexual harassment prevention policy requirement. October 9th, 2018 was the implementation deadline. So, in other words, all of you should have adopted and implemented a sexual harassment prevention policy by October 9th, 2018. If by your processes or for some reason that has not been accomplished, you really need to get on your horse and ensure that you're adopting and implementing a compliant sexual harassment prevention policy. And that must be distributed by October 9th or as soon as possible now to all of your employees. It can be distributed electronically or in written form, but if you distribute it electronically, you must ensure that employees can download and print your policy. And that policy must meet certain minimum standards. And the first is that the policy must prohibit sexual harassment consistent with guidance issued by the Department of Labor and the New York State Division of Human Rights. And it must provide examples of prohibited conduct that would constitute unlawful sexual harassment. And in this regard, I want to make it clear here that sexual harassment does, in fact, according to the New York State Division of Human Rights Law, include harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. And I say this because there is some confusion if you're following along with the law, with legal developments on the federal level. challenges are being brought as to whether Title VII of the Civil Rights Act of 1964, which also prohibits discrimination on the basis of sex, covers gender identity and transgender status. You need not worry yourself. The New York State law applicable to you, in fact, does cover, and there is no question, covers these statuses. So you have to ensure your policy makes that clear. You also need to include in a compliant policy information concerning the federal and state statutory provisions concerning sexual harassment, the laws that cover it, the New York State Executive Law or Human Rights Law, Title VII of the Civil Rights Act of 1964, and remedies available to victims of sexual harassment, as well as a statement that there might be local laws. Now, I would guess that this is not a provision you would have had in your existing sexual harassment prevention policy, presuming that you had a written policy in place, so you need to ensure that's included. You also need to provide a complaint form for individuals who wish to complain of sexual harassment. And you need to advise employees where they can find that complaint form. But again, I want to dispel some confusion in this area. While you have to provide that form, and you must have one under the law, you cannot require an employee to complete that form in order for you to consider the employee to have made a complaint under the law. You can encourage them to. You can fill it out with them, but you can't require it. I know some employers in the past, and it's been a mistake in the past as well, now it's very clear, has said, well, they didn't fill out the form. They only verbally stated it, but they didn't follow through. If an employee makes a complaint to a supervisor verbally or to a compliance officer or anyone in a supervisory capacity, our entity knows or should have known of that complaint and is required to take action. Your policy must include a procedure for timely and confidential investigation of complaints that ensures due process for all parties. Your complaint process must be as confidential as possible under the circumstances. And it has to be clear to whom you may complain, a supervisor, a manager, or particular individuals to whom you may bring your complaint. It must also inform employees of their rights to redress in all available forums for adjudicating sexual harassment complaints administratively and judicially. So in other words, an employee can bring an internal complaint pursuant to your policy, but you must also advise them that they can bring a complaint to the Federal Equal Employment Opportunity Commission within 300 days of the alleged wrongdoing. They can bring a complaint, if they choose, to the New York State Division of Human Rights within 1 year of the alleged harassing behavior that they are complaining about. And if they miss those deadlines, they also have 3 years to proceed directly into New York State courts on their claims of discrimination or harassment. I am guessing, at least in the policies we've prepared for our clients in the past, we did not include that information in those policies, and it must be in a legally compliant policy pursuant to the new law. We also have to clearly state that sexual harassment is considered a form of employee misconduct and that sanctions will be enforced against supervisory and managerial personnel who knowingly allow such behavior to continue. Now, this is really important because it gives you some insight into the New York State Division of Human Rights view. Supervisory and managerial personnel can bring liability to our organizations for their own actions of discrimination and harassment, or for their failure to act when claims are brought to their attention or when they witness behavior that they know is not in keeping with our policy and rises to the level of harassment or discrimination. So that tells you we really need to educate our supervisors and managers as to their obligations under the anti-discrimination law. Additionally, our policies must clearly state that retaliation against individuals who complain of sexual harassment or who testify or assist in any investigation or proceeding involving sexual harassment is unlawful. That is not something new. That must be in policies, and quite frankly, that is the biggest area of complaint made to both the EEOC, the Equal Employment Opportunity Commission, and the New York State Division of Human Rights, that individuals who feel that they have complained of harassment or discrimination feel that after that, negative action has been taken against them that would dissuade a reasonable person from making a complaint. Now let's move. So that's what you have to have in your policy. We're going to talk about the fact that we disseminated a policy. NYMER has for all subscribers. In fact, New York State also provided on its website and disseminated a model sexual harassment policy. Of course, despite the fact that the legislation was signed in April of 2018, it did not disseminate that model policy until October 1st of 2018, giving you a whopping 8 days to comply and implement your own sexual harassment prevention policy that was in keeping with the law. So I think that's what created a lot of anxiety. Thankfully, when we talked to sexual harassment prevention training, if we could move to the next slide. Could we change the slide?
It should have changed, Susan, on sexual harassment prevention training.
There you are.
Okay.
Luckily, what happened was, originally with the legislation, there was a statement that the prevention training, the required annual training, had to be completed by January 1, 2019. Thankfully, that requirement has been eased, and in fact, all of you have until October 9th of 2019, a full year, to provide training to all of your employees. And thereafter, you must complete annual training provide annual training to your employees. And that can be conducted on, for example, a calendar year basis, so that you could select a particular time of year each year that you will provide that annual training. Additionally, the New York State Division of Human Rights recommends that for all new hires, you conduct training, quote, as soon as possible. What we recommend there for best practices is that you are sure when employees are hired and in the process of their onboarding, you are supplying them with a legally compliant sexual harassment prevention policy, that you are going over the provisions of that policy with employees, that you are providing them an opportunity to ask questions about the policy so as to fulfill those minimum obligations. And for your training then, there are certain minimum standards that the law now requires. Your training must include an explanation of sexual harassment that's consistent with the New York State Division of Human Rights guidance. It must include examples of conduct that would constitute unlawful sexual harassment. It must include information, again, concerning the federal and state statutory provisions concerning sexual harassment and remedies to those who are victims of sexual harassment. It must include information concerning employees' rights of redress and all the forums they can go to have their complaint heard. And it must include information addressing conduct by supervisors and additional responsibilities of supervisors. And it must be interactive. And this, until October 1, when the New York State Division of Human Rights came out with its pronouncements regarding this training, there was a lot of anxiety about what does interactive mean? Does it mean that we must provide live training? And in fact, that was clarified to say that the training may be online as long as it's interactive. If we could go to the next slide. And examples of employee participation that makes that training interactive, if it's web-based, are the following. If your web-based training has questions at the end of a section and the employee has to select the right answer, or if employees have the option to submit a question online and receive an immediate answer or an answer in a timely manner, that will be deemed participative and interactive. Or perhaps if we require a feedback survey from employees following their completion of the training, wherein they express what they learned from that training. If the training is in person or live, which is frankly always the most effective training, if the presenter asks the employee questions, it will be deemed interactive. If the presenter gives time throughout the presentation for employees to ask questions, or again, if a feedback survey is provided to employees to turn in after they've completed the training, all of that will be deemed to comply with the requirement that the training is interactive. And now, if I could, I would like to turn to NYMER's model policy overview. As I stated, and I believe Susan mentioned, NYMER disseminated a model policy for subscribers if they chose to implement it. And that model policy meets the minimum standards for sexual harassment, for the sexual harassment prevention policy, but it goes a step further. It actually constitutes a comprehensive policy against discrimination and harassment, covering all forms of prohibited discrimination and harassment under both federal and New York state law. Because sexual harassment is one form of sex discrimination, and sex is but one of a laundry list of protected statuses that we have to be concerned about to ensure there is not discrimination or harassment based on that laundry list of protected statuses, including things like age, religion, disability, race. None of these statuses are any less important than discrimination or harassment based on sex. So NYMER made a determination that it would issue a comprehensive policy to ensure that if you implement that, you are ensuring consistency in preventing and addressing prohibited discrimination and harassment. If you did not choose to implement that policy and implemented a sexual harassment prevention policy, for example, some version of the policy that the New York State Division of Human Rights has put out on its website, I would encourage you that you should be visiting your other anti-discrimination and harassment policy to make sure that that policy is comprehensive, contains the complaint procedure that's in the sexual harassment prevention policy, so that you have consistency. And if you are called upon to defend a claim or to handle a complaint that is based on a protected status other than sex and sexual harassment, you are equipped to do so through that other policy. And so now if we turn to the policy implementation and urgent action items. Again, I can't stress enough that October 9th, 2018 was the implementation deadline. If you have missed that deadline, I encourage you to implement a policy that meets the minimum requirements as soon as possible, because if in fact you don't do that and you receive a complaint of discrimination or harassment that relates to sexual harassment, the Division of Human Rights will be calling upon you to demonstrate that you had a policy that meets the minimum requirements in place. And if you don't, then that will bring discredit to the organization right at the outset as you respond to that discrimination or harassment claim, and it will severely hamper the ability to defend you against liability, because certain of the defenses that we employ state that and require that you have a legally compliant policy, a legally compliant complaint procedure, and that you followed it and remedied the discrimination, or the employee failed to avail themselves of that policy. So that's really important. And then what I tell you as an urgent action item is, if you are using the NYMER model policy, it requires you to identify compliance officers. And even if you're not using that policy, compliance officers are the quarterbacks of our policy, of policy implementation and policy enforcement. You need to centralize that process, and I would tell you that the selection and identification, it should state individuals' names, their locations. Employees should be aware of names, locations, meaning addresses. How can I get to this person to make a complaint, and telephone numbers. And we should be very careful in our selection process. We would like to, if at all possible, see that you name more than one compliance officer, that there be a male compliance officer and a female compliance officer, if that is a feasible option. And also that you ensure that you are dedicated to ensuring that we are educating our compliance officers on the policies that we implement, as well as the laws against discrimination and harassment, because they are going to be on the front line and responsible for actual implementation of the policy. I can tell you, in my more than 25 years of experience, I have often seen individuals who are technically named or hold the title of compliance officer in our municipal organizations, and they are not particularly knowledgeable about what their role, responsibility is, or frankly, what is required by the anti-discrimination and harassment law. And that could prove fatal to effective policy implementation. Also, although not required by the law, if you have implemented the policy, we recommend that you are collecting and maintaining employee acknowledgement of receipt forms that they in fact received your legally compliant sexual harassment prevention policy when they received it, that they read and understand it and have had an opportunity to ask questions. While retention of that kind of material is not required by law, it will be effective to show that your organization, your municipality, is legally compliant. We also recommend, and while it's not required, that you are posting your legally compliant policy in visible areas in the workplace. And this is particularly important because, again, non-employees have rights under your policies, the contractors, subcontractors, vendors. And while you're not required to disseminate your policy to them, if you can demonstrate you had it in a visible area, that will go a long way to ensuring that you are advising all of those individuals of their rights under the law. Next. And now, finally, I want to talk about the notion of NYMER's model training program. Live Train the Trainer seminars will be rolled out in the early spring in multiple locations. At those training sessions, you will learn and actually take part in a live training session where we train on the legally required policy and conduct an actual legally compliant training. And beyond that, what we will also be doing is bringing those policies to life and providing training regarding actually implementing the complaint process, ensuring you have effective implementation of the complaint process, and providing techniques to ensure that you have a prompt and thorough investigation that provides due process to employees in compliance with law. And in this regard, I know in my experience, someplace where I see pitfalls when we're defending claims is when we get to that notion of, did an employee bring a complaint? Did our supervisors understand that they were bringing a complaint? And then did we take appropriate corrective action in the way of a prompt and thorough investigation? Because in the first instance, we can go so far and create these wonderful policies, we can disseminate them, but they're only as good as when they're brought to actual life by all of you and those you charged with responsibility to implement them. And so we are really encouraging people to attend those seminars, and we are encouraging for whoever you send to those seminars that they complete this webinar before they attend, to give them this background information, because we're really going to want to get into the nuts and bolts and presume everyone has some overview knowledge. Something that I think is really important, again, when we talk about that notion of prompt and thorough investigations, another pitfall that we have seen in our defense of claims of harassment and discrimination is the notion of what is a prompt investigation. We know that our municipal employers are very busy trying to actually run municipalities and their departments. But to get a feel, the New York State Division of Human Rights originally, in conjunction with this legislation, had recommended that policies, and it was going to be a requirement that policies indicate that an investigation will be completed within 30 days from the complaint. That's a pretty short period of time, but it gives you a window into the division's view of what is a prompt investigation. Now, after commentary from practitioners, the division eliminated that 30-day requirement, but nonetheless, you know that it's their mindset, and you better be able to explain that it's the complexity of the investigation or other intervening factors that have required that investigation to take longer than 30 days to complete. At the Train the Trainer program, we'll also be talking about the written reports that are required, issues like even selecting the investigator who will investigate, and then ensuring that they're investigating to ensure due process. So we really encourage you to attend those. NYMER will also be updating its online harassment prevention training program after January 1, 2019. to allow you to use that as a tool to comply with the training requirements of the sexual harassment legislation. But what I can say in sum, if we all keep to the notion that everyone has the right, and I'm on my soapbox admittedly, to come to work and be treated with dignity and respect, this is a great wake-up call to all of us that we have to pay particular attention to our anti-discrimination and harassment policies at this time. We have to ensure that our supervisors and our managers are well-versed in their responsibilities, and that we have a quarterback who is assigned to ensure that complaints are handled promptly and appropriately, and appropriate corrective action is taken where necessary. If not, we're seeing that there's going to be heightened scrutiny, certainly with regard to sexual harassment claims, if we don't take this as the wake-up call to make sure we're doing that. So that said, that gives you an overview of what's required. You're going to see a lot of information coming out from all kinds of sources, not just the New York State Division of Human Rights and not just NYMER, with regard to training programs that you might use to ensure that annual training. And you just need to be sure that whatever training program that you are employing, that you're ensuring that it meets the minimum standards as set forth in the new law. So that said, I know this was a quick overview and a lot of information, but we are happy to take any questions that you might have.
Thank you, Susan. We did get a couple questions sent to us. One was, do employees include paid and unpaid elected officials?
Yes.
Okay.
That is my understanding, yes.
Okay, thank you. There was another question too. Is a resident or constituent considered a non-employee?
A resident or constituent would be deemed a non-employee if they are providing a service in the workplace. So if they're contracted to provide a service in the workplace.
Okay, thank you.
But it is not just an employee that's coming off the street to obtain a service. I'm sorry.
Okay, thank
you.
Okay. We had another question. Will NYMER make available posters with its model policy? We're going to look into that. I think we might be able to generate that, so we will inform you of that once we have those available. It was a good suggestion. I had a question about NYMER's online training be available for municipalities to use with their employees, and yes, it will be. We'll be updating both our employee training, and we also have a separate training that's for supervisors and administrative staff as well, and that will be updated after the first of the year. And then, do you have a generic complaint form? And yes, that was attached to the model policy sent around. So we will include that again with the email when we send out the PowerPoint presentation. It will include our sample policy, which included the sample complaint form. Let's see, is there an acknowledgement form that non-employees, such as vendors, would be required to sign? Susan, do you have any suggestions in regards to that?
No, there is. You can certainly create one if you wish. That is not required. You are not required to disseminate your policy to non-employees, but that's why the division and we are heeding that recommendation that you need not disseminate it to every vendor and or non-employee, but that you post it in visible areas.
Okay. If you think an acknowledgement form would be helpful, maybe, Susan, we can work with you on a sample and provide that to our members?
Sure. That could,
okay.
And I will say, if you want to really dot your I's and cross your T's, you might consider that. However, that could be quite cumbersome because then we'll get into issues of whether you have provided every non-employee with that policy, and you may wish to just take the position of posting.
That's a good point, Susan. Thank you. We also have another question. Are board members included, such as planning board members?
My understanding is yes at this time.
Okay. Someone is asking, sample policy section 12 distributed at the beginning of each year, is this mandatory? Does the policy need to be distributed to everyone at the beginning of the year, Susan?
Oh, no, you do not need to distribute the policy annually, but you do need to ensure it's distributed to new employees. And then if you revise your policy in any way, you're going to want to publish it and distribute.
Okay, thank you. We also had a question about a sample acknowledgement form for the employees that they've received a sample training and policy. We can provide one of that with our handbook when we send it out. So yes, we can assist people with that. Let's see. An employee we had asked about the committee be after. Let's see if I can.
If I could just speak to that as well.
Yeah.
If you
Thank you.
Dependent on the mode of training that you choose to provide, if it's live training, for example, and there is a PowerPoint presentation associated with it, you would want to be sure that you maintain the PowerPoint presentation, a sign-in sheet for employees to show that they attended the training, and maintain those materials so that you can demonstrate that you actually conducted the training and you can show who attended that training. If you use other forms, you want to be sure that you have an acknowledgement form that the employee completed the training.
Thank you, Susan. And also for those of you who've been on the NYMER Online University, or if you haven't, we can assist you with that. And there is a way to track that training electronically and to disseminate that policy and training electronically. So contact us about that if you need help with the online university, and we can help you with the tracking. It looks like someone's asking about whether they should have a committee after a complaint is received, and if the compliance officer should be part of that committee.
I'm not sure what we mean by committee, but we do need to ensure that we're designating an individual in the organization, a compliance officer, for example, for supervisors to bring complaints to, and for employees to complain to, who will ensure that there is the intake of the complaint and perhaps assist an employee in completing a complaint form, or to whom the employee brings the complaint. And that compliance officer would then, and if you choose to create a committee, it should be a very select committee and certainly should not include any accused employee. But if you want to create a committee to ensure that then you process that complaint by way of a prompt and thorough investigation. The concern when committees become too large is that it bogs down action on the complaint, and actions that have to occur immediately, like preserving documentation or information or a setting in which discrimination or harassment took place. But you certainly need to designate a quarterback for these complaints.
Okay, thank you, Susan. We also have questions about part-time and seasonal employees. So for instance, the example we were given is those municipalities that have snowmen or snowplow drivers, wingmen, that they call in only if needed. They may call them in at 2 o'clock in the morning on a very occasional basis. Can you speak to whether those people need to receive the training?
They do need to receive the training according to the new law.
Okay. Who can be a compliance officer? Can it be staff, trustees? Is there any requirements in regards to the compliance officer?
It should be someone in the organization with high-level managerial responsibility. It could be a trustee as well. But you need to have alternatives so that if the compliance officer is the one accused of the discrimination or harassment, there's an alternative source to go to.
Okay, thank you. If a town sponsors an event, are they responsible for sexual harassment issues that arise at that event with the vendors?
I'm not sure I fully understand the question, but if the town sponsors an event and we have vendors at the event providing service to the town, yes, we would have responsibility and liability to that vendor if they are sexually harassed.
Okay, thank you.
We have to take appropriate action.
And I think the key would be there that is definitely a town-sponsored event and the town is involved with organizing and procuring those vendors.
Right, and quite frankly, the law also recognizes that you may have some limitations in your ability to remedy the harassment or dependent on the nature of your relationship, but you have an obligation to act in some capacity to try to eliminate the harassment or to address it.
Okay, thank you. Could you clarify the new rule in regards to the competitive bidding requirement as regards to a general contractor engaged to manage the construction project? For instance, would they be required to be in compliance, electrical service providers, et cetera?
Right, if you require competitive bidding and they had to bid on the job, they must be in compliance.
Okay. Also, there's a question in regards to, is there blanket training, or I guess they're asking, for instance, they have a code enforcement officer that works for other municipalities. So can they get the training from one of those other municipalities? I think you might have touched on that a little bit, Susan, but if you could just again mention how that works if somebody's working for more than one employer.
Okay, if someone is working for more than one employer and they can certify that they received the training from the other employer, that can constitute compliance, but I say that with a big caveat because then you are relying on someone else's training and you want to be sure if you're going to do effective training that that individual understands the nuances of your policy and to whom they report any complaints of discrimination or harassment and the expectations of your municipality. So you are nonetheless liable, and so you do that a bit at your peril unless you're entirely confident as to what the contents of that other training was.
Okay, thank you. Are board members required to participate in the interactive training, or if they just receive a copy of the policy, is that sufficient for the board member? And I'm assuming here they're talking about town board members or village trustees.
They should be participating in the interactive training.
Okay.
Yeah.
Okay. There's a question here. Workplace violence has to have a committee with a union and non-union member. I believe they're asking here if the sexual harassment has the same requirement in regards to union.
No, it doesn't. It doesn't have that same requirement that the workplace violence training requirement has. However, one thing I would recommend to all of you who deal with, and that's probably most of you on the line dealing with unions in your workplace, it's really important that we get them on board with the anti-discrimination and harassment policies, including sexual harassment. Because in my experience, something that I have seen and what creates utter confusion and problem is that employees believe if they bring a complaint to their union rep, their local union rep, whether it's a labor relations specialist or actually an official of the union, that they have made a complaint to the municipality, and they have not. And so employees in the first instance need to understand that is not making a complaint. It has to be made to someone with supervisory or managerial authority within the municipality or to a compliance officer. And that's why I say identifying those compliance officers is really important. And also what happens at times, and what in my experience I have seen, is an employee will bring a complaint to a union rep, and they have recommended that the employee not bring the complaint forward and have told a lot of different tales about how the individual will be retaliated against. And that is problematic. Our unions don't want to see, quote, anyone get in trouble, and they attempt to handle the employee's issue of, let's say, sexual harassment within the union and don't want to bring it to the employer's attention. That usually has a way of exploding at the end of the day. So we need our unions on board. And while I know sometimes some of us sitting here are concerned, oh, we're going to get flooded with complaints, we typically don't get flooded with complaints by virtue of our training and dissemination of policies. And in fact, believe it or not, you really want people to bring complaints forward when they're small, because you can address those issues. And when our supervisors are walking the walk and talking the talk and enforcing our policies, we are more often than not dealing with issues when they're small rather than when they fester, become huge, and now we're defending ourselves in front of agencies or in the court system. We want to deal with those problems when they're small. And when we do that, we often can remedy them by way of counseling or verbal warnings or written warnings or additional training and education. And it doesn't require, significant disciplinary action. But when things fester...
Thank you, Susan. I know
Sure.
we've got a few more questions to get through. Our webinar was to end at 3 o'clock. Susan, if you're agreeable to stay on the line, we'll try to take a few more of these questions, but I know some people need to get off. So again, just a reminder, we will be sending you out an email with the PowerPoint information, with contact information. It will also include a copy of our sample harassment prevention policy, along with the complaint form and information about NYMER's website, where you can get additional information as well. So if you need to leave us now, we certainly understand. But Susan, I think our connection will hold. It is 3 o'clock. I think we'll stay on. If we do lose people anyway, you know how to get a hold of us. But Susan, if you want to stay, we'll go through just a couple more questions.
Sure.
Okay. So one of the questions we have is what to do when an employee refuses to take the training.
The law, the New York State Division of Human Rights has made a pronouncement on this, that it is our obligation to ensure that employees receive training, and if they refuse training, you can pursue administrative remedies, meaning disciplinary action.
Okay, thank you. In the competitive bidding process, which takes precedent? The fact that the bidder has a sexual harassment policy or the most cost-effective bid? Should we reject a cost-effective bid that lacks a sexual harassment policy within the bidder's company? Any thoughts on that, Susan?
It is my understanding, this law is new, but it is my understanding that you cannot accept a bid that doesn't have the required certification if competitive bidding is required. Okay,
thank you. Also, we have a question about a restaurant operator. This could apply to other operations that the town leases or permits to other individuals, but this case has to do with a restaurant operator that licensed a town park facility. Should that vendor be required to adopt a policy and train the employee?
Well, every employer in New York State, regardless of size, is obligated to adopt and implement a sexual harassment prevention policy. So yes, they should.
Okay, thank you. Okay, can you force an elected official to attend? I'm assuming they're referring to attend the training.
I suppose you can't force anyone to attend the training. It would be very disheartening to know that an elected official would not support and attend the training. And I don't see a mechanism to force that issue.
Right. Okay. The next question is, will there be a standardized training design? I'm not sure if they're talking about NYMER or about Department of Labor, but I believe Department of Labor has provided a PowerPoint presentation that individuals can use for the sexual harassment.
The New York State Department of Labor has put out model PowerPoint trainings that they look for you to conform to your own policy, and they have put out, I believe if they have not yet, they're going to be putting out some kind of webinar type training.
And again, NYMER will be working with Susan to develop our own training program, which will be available to our members, which will include the anti-harassment training. So that information will be forthcoming here after the first of the year. The next question I have is, if a person makes a verbal complaint, should the compliance officer fill out a form for a record or for a paper trail?
Yes, the compliance officer is going to typically be the person who actually intakes the complaint. So if the employee makes a verbal complaint, but they don't submit a written complaint on the complaint form, when the compliance officer is intaking that complaint, I would recommend that they actually complete the complaint form with the complainant, so that there is a written record of at least the totality of the intake of the complaint, what the employee is complaining of.
Okay. Next question has to do with park facilities. Should organizations who are using the municipality's parks or facilities be required to follow the municipality's policy? The example they gave is the softball league using the municipal park.
Just taking that question in, I don't see how the employment policy would apply to them.
Right, they wouldn't be an actual employer, so it would not apply. Okay, thank you. What if an employee is absent? And again, I'm assuming that they mean absent during the training. That employee would have to make up that training at another time?
Yes.
Okay. Do judges who are hired by the town also have to take the course? Again, I think they're referring to the training, and it sounds like these are employees of the town.
Right, yes.
Okay, and I think we already went over town board members. Let's see, in a competitive bid situation, is the compliance officer to be named within the contract or the town? I'm assuming they're talking about the vendor that's bidding. I'm not sure about that question.
No, the compliance officer issue would not have applicability to the competitive bid. The compliance officer is named in your policy as the individual to whom complaints can be made and who will handle the ultimate complaint, or quarterback it, if you will.
Okay. Next question. What happens when the low bid is from a vendor in Pennsylvania and they have no policy in effect because they're not subject to the New York State laws affecting sexual harassment? What would happen then if they are the low bid? Could they be accepted? They're not a New York State employer, but they are going to have employees in New York State.
I'm looking here. I don't know that I know the answer to that off the top of my head, but I'm looking at the statutory provision. I'd have to defer on that response for the moment.
Okay. I think I know the individual that asked that question, so we'll try to get back to you, or if we don't, please let us know. It was a good question. And I think that's the end of our questions from now, but certainly, once you get off the webinar, if you think of something else, please feel free to contact us. You will be receiving an email with the PowerPoint and other information we discussed. So, Sue McLaren, thank you very much for your time today, and thank you everyone for participating. Have a good day.
Thank you.